Welcome to Disputes 180. This is 180 seconds of what you need to know from the world of litigation and investigations. Brought to you by the wonderful team here at Paul Hastings in London. We have a link below to lots of great content on what we're covering today. So let's waste none of your precious time. Let's dive straight in. This is Disputes 180. Today we're looking at an amendment to the Civil Procedure Rules, which is more interesting than it sounds. It feels like we've been talking for ages about how alternative dispute resolution is going to change the way we litigate, but now those changes are here. From 1st October 2024, the Civil Procedure Rules have been amended to allow judges to order that parties engage in efforts to resolve their disputes away from the court. Before looking at the amendments themselves, let's look at some of the background. Mediation as a way of resolving differences between parties has been around for years, and it has increasingly been used to resolve a growing range of commercial and regulatory issues. Up until last year, however, mediation could not be ordered by a court. The reason was a long-standing appeal decision which said that requiring parties to mediate was contrary to their right to access the court process. But the law has now changed with an important new judgment. Now a judge can lawfully order parties to engage in non-court-based dispute resolution if the situation meets the following test. The order does not impair the very essence of the claimant's right to a fair trial, is made in pursuit of a legitimate aim, and is proportionate to achieving that aim. And following this judgment, the Civil Procedure Rules have been amended to reflect it. The CPR is based around an overriding objective to ensure that cases are dealt with justly and at proportionate cost. Under its general powers of management, the court may now order the parties to engage in alternative dispute resolution or take any other step or make any other order for the purpose of managing the case and furthering the overriding objective, with the aim of helping the parties settle the case. The amendments to the CPR do not provide guidance on how this new power should be exercised, and this reflects the Court of Appeal's approach, which declined to identify fixed principles but referred to a number of factors which might be relevant. To give the changes force, they are backed up by potential cost penalties. Where a party fails to comply with an order for alternative dispute resolution or unreasonably fails to engage in alternative dispute resolution proposed by another party. It's clear that the courts and the government are keen to find new ways for disputes to be resolved, taking pressure off the court system and speeding up the process of justice. Mediation looks likely to be a key part of this, and parties are going to need to think carefully about their options as a part of their case strategy. The detail on all of this is in our Stay Current Bulletin, which you'll find in the resource page which accompanies this video. And of course, if you'd like to talk more about it, please do get in touch. And that's your 180 for today. If you want to join a live version, we host regular events at the Paul Hastings office here in London, including our two flagship series, Developments in Disputes and The Future of International Arbitration. To make sure you don't miss out on any of this great content, follow our Paul Hastings LinkedIn page. If you've enjoyed this edition of Disputes 180, why not look out for the next one? That way, you'll have done a full 360.